Lynn Luker. Not a threat. It's a promise. Based upon the documents that I have in front of me right now, I'm present. Clearly shows that you left your client abandoned on December 29, 2010. Am I one pissed off son of a bitch? You bet I am. People like you, Lynn Luker, is the reason why society is like it is. Because from what I read, you don't like things to be brought in to federal guidelines. Because it is about also Social Security, you know what I mean? If anybody else was in my shoes, they'd do the same thing. I'm coming. It's not a threat. It's a promise. You wrote a letter to me in regards to my, on August 1st of 2013. And it reads, I am writing to respond to your phone message of July 31st of 2013. Through some unfathomable thought process, you continue to insist that I am your attorney and that I should call and discuss the case with you. I have not been your attorney since December of 2010. I'm not going to be your attorney. I have specifically not responded to your many phone messages, emails, social media contact attempts, faxes, because I am not your attorney, and I have nothing to communicate to you. A number of your phone messages and postings have contained threats. Those have been reported to the police. Well, I think you just defamed me there, Mr. Luker. Produce a threat that I've ever done. Do not call me anymore, and further phone contacts at my business, home, campaign, or otherwise are not welcome and will be reported as phone harassment. Do not attempt to contact me in person, at my business, home, or any other place. This will be reported as trespass. Well, Mr. Luker, I can come to the Capitol there and ask you questions. You can't tell me where I can go and where I can't go. I don't care how long you've been on that seat that you sit on. If you have legal documents that you feel you need to copy me on, do that through the legal process set up by the court rules. Yeah, we know how you help the court rule, don't you, Mr. Luker? I think you're a little warped in the mind there, Mr. Luker. Here's your letter of August 1st of 2013. Okay? All right, Mr. Luker? Mr. Luker, on December 23rd of 2010, I'm coming. It's not a threat. It's a promise. Encloses a copy of the Industrial Commission's order granting my withdrawal from the case. It indicates that you are now representing yourself until another attorney, if any, files an appearance in the matter. Pretty ignorant there, weren't you? Arrogant, or whatever you want to call yourself. If any will appear, yeah, okay. Well, I haven't been able to, but you know what? It's okay. Also enclosed are copies of my affidavit of service. Well, I won't even read you the rest of it. I won't waste anybody's time. But the point is, Mr. Lynn Luker, this is your letter of December 23rd, stating right there, in your own words, that I am representing myself at this moment. That means December 23rd of 2010, I was representing myself because you were a quitter. Then Mr. Luker. This is the letter that I wrote to you after you contacted me about my case again. In order for you to come back, you wanted me to write you a letter. To me, Lynn Luker, this is a new contract. Because you do speak of it. Dear Lynn Luker, December 27th, 2010, I would like for you to move forward and settle my claim for the $120,000 on claim number 2008-013505, which is the one that went before the Supreme Court in 2012, based on the Industrial Commission's findings of facts and conclusions of law that clearly is not held together by substantial evidence. I'm coming. You motherfuckers have fucked with the wrong person now, man. I will also close my claim for SSD. Ooh, Mr. Luker. I haven't even got to the Social Security part now, have I? Thank you for your time on this matter. Me, James Clark. Okay, Mr. Luker? Mr. Luker. Didn't think I'd make it this far down, did you? December 29th of 2010. Okay, Mr. Luker? Let me read it to you. Dear Jim, this is written confirmation that I received your letter of December 27th of 2010. This is my letter that he received, that he speaks about, asking that I accept the offer of the $120,000 to close my claim. And I do have the confirmation for this letter. And I contacted Mr. Hall according to your request. So that means he started working on my claim again, based upon my new letter of contract. Because in this letter right here, he states on the 23rd that, it indicates that you are now representing yourself. And that's on December 23rd of 2010. All right, Mr. Luker. As we discussed on the phone yesterday, the sorority chose to change its offer after your rejection of the prior one. That means the one prior to him quitting on December 20th of 2010, and granted by the Industrial Commission on December 21st of 2010. I didn't even get a chance to know that he was doing it until I was getting shit in the mail. Isn't that right, Mr. Luker? And that was because of the December 15th letter I received from Social Security, isn't it? Of 2010. It's really why you quit, isn't it? I ain't even got there yet. Piece of shit. And that's just an opinion. Since you are a legislator and you run for office, you've got to understand that people don't like you. So it's an opinion. As we discussed on the phone yesterday, the sorority chose to change its offer after you rejected the prior offer. The offer is still $120,000, but they now want credit for the impairment previously paid of $27,531.90. That's Dr. Hansen's impairment rating based on my crush injury that almost cost me my life in 2008. There is also a child support lien outstanding of $4,372.07, which would have to be paid from the settlement. I'm not going to hide nothing. That would now leave a new funds available before attorney fees and costs of $88,096.03. You indicated that you were not interested in that offer. Of course I was. I needed the help. It wasn't about money, now was it, Mr. Luker? That's what pissed you off the most. Other than you were pissing me off because you refused to call any of my physicians. You're not even the one that did the deposition of Dr. Hansen. I found out it was the state insurance fund. And I found out before the hearing that they were also had requested the deposition of my physicians and not you. How come, Mr. Lynn Luker? You indicated that you were not interested in that offer, and I conveyed that to Mr. Hall. So as we were working with the attorneys again, but both y'all were wrong by coming back in the color of darkness. Now weren't y'all? Because you weren't supposed to do that. Therefore, you indicated that you were not interested in that, and I conveyed that to Mr. Hall. Therefore, we are back to the status where before your letter of December 27th of 2010, where the order of withdrawal is effective, and I am no longer involved in the case. I understand that you did pick up the files from the Industrial Commission. I am sorry that this last attempt to resolve the case did not work out.